Nebraska's landlord-tenant law is governed by the Uniform Residential Landlord and Tenant Act, found in Nebraska Revised Statutes, Chapter 76, Article 14. Nebraska was one of the states that adopted this model act fairly closely, which means the habitability framework here is well organized and relatively predictable. Under Nebraska law, landlords must comply with all applicable building and housing codes that materially affect health and safety. You're required to make all repairs necessary to keep the premises in a fit and habitable condition, maintain the structural integrity of the building, keep plumbing systems functioning with hot and cold running water, ensure electrical systems are safe, provide adequate heating facilities, maintain any air conditioning system that was provided with the unit, supply working smoke detectors, keep common areas safe and clean, and provide adequate trash receptacles and arrange for removal where applicable. One thing Nebraska does well is lay out landlord obligations in plain language. Section 76-1419 of the statutes gives a clear list of what's required, and there's not a lot of ambiguity. That's actually helpful for landlords because you know exactly what the standard is. No guessing, no surprises. Nebraska's repair process follows the notice and cure model. If a habitability issue arises, the tenant must give the landlord written notice describing the problem. For conditions that are not emergencies, the landlord has 14 days to begin making the repair. If the condition involves a serious threat to health or safety, the timeline is shorter. The landlord must respond promptly, and courts will evaluate what was reasonable given the circumstances. If the landlord fails to act after proper notice, Nebraska tenants have several remedies available. They can pursue damages in court for breach of the implied warranty of habitability. They can seek rent abatement, meaning a court-ordered reduction in rent reflecting the diminished value of the unit during the period it was deficient. And in cases involving material noncompliance that affects health and safety, the tenant can terminate the rental agreement after giving proper notice. Here's something that makes Nebraska a bit more landlord-friendly than some neighboring states. The statute does not include a broad repair and deduct remedy. Tenants can't simply call a plumber, fix the problem, and deduct the bill from next month's rent. Instead, they need to go through the court system to seek relief. This gives landlords more control over the repair process and protects against situations where tenants might authorize unnecessary or overpriced repairs. Nebraska does allow the landlord and tenant to agree in writing that the tenant will handle specific maintenance tasks. But this agreement has to be made in good faith, must be supported by adequate consideration, like reduced rent, and cannot include essential services like plumbing, heating, or electrical systems. So you have some flexibility in structuring the relationship, but the core habitability obligations stay with you. Nebraska's anti-retaliation protections are codified in the statute. Landlords cannot raise rent, reduce services, or file for eviction in response to a tenant exercising their legal rights, including making habitability complaints or contacting code enforcement. The protection applies regardless of whether the complaint was made to the landlord directly or to a government agency. For a complete guide to Nebraska's habitability requirements, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for the rest of our state-by-state landlord series.